I'm Darcel Lobo of Dow Law Firm, and here to talk to you today about probate and the options to avoid probate. Many times when clients come to our office and they want to discuss estate planning, one of the things that they have questions about is the probate process and how they can avoid probate if they would like to do so. And so we do have a few options here in Washington State about how to avoid probate with your estate planning. One of the main options and one of the more common options for this is a revocable living trust. That trust owns the assets of your estate. And so during your lifetime, you are the trustee of your own trust and you can administer your assets as you normally would. So if you had any real estate, you could still sell it, you could still rent it. If you wanted to refinance it, you have complete control over those assets during your lifetime. However, at your passing, you will appoint someone to act as your successor trustee who will step into your shoes and will continue to administer assets according to your revocable living trust. With this process, there is no need for probate as long as your assets are properly titled in the name of the trust. And namely, that's going to be any real estate that you own, your personal, your primary residence. And if you own any other real estate, you'll want to ensure that that is titled in the name of the revocable living trust once it's been created. And you do that via a quitclaim deed. Another option besides a revocable living trust is a transfer on death deed. Now, this only works for real estate. It doesn't work for any other types of property. It's almost like making a beneficiary designation for your real estate. The only concern with this option that I personally have is that when we do the transfer on death deed, it makes a public record immediately of who is going to inherit that home, who is going to be the beneficiary of that home. So you'll want to ensure that that beneficiary doesn't have any kind of outstanding judgments, liens, tax debt, any kind of domestic support obligations like child support or alimony, as they can, and they will, attach to the real estate once it does transfer into the beneficiary's name. So it's something to really consider as far as who the beneficiary is if you are looking at a transfer on death deed. The revocable living trust applies to all of your assets, whereas the transfer on death deed, you'll need to do one for each piece of real estate that you own, and it will not apply to any kind of other assets you have, such as vehicles or personal possessions or any kind of financial accounts. It is solely for real estate, but it is an option as well to have that property transferred to someone at your passing through the transfer on death deed and to avoid probate. Another option is to ensure you have beneficiary designations on all of your investment accounts. Any kind of financial account should have a beneficiary listed. So your checking account, savings, CDs, any type of life insurance policies, retirement policies, your 401ks, any kind of investments, you want to ensure that you have a beneficiary listed and possibly an alternate beneficiary as well if needed. So the beneficiary listing, upon your passing, that beneficiary would automatically just receive those funds outright without the need for a probate. And so make sure that your beneficiary designations are all current and up to date. And if you have minor children, please ensure you are not listing that minor child as a beneficiary of that asset, because a minor child is not competent under Washington state law to inherit anything if they're under the age of 18. So there are different options for minor beneficiaries. If you have a child or a grandchild, niece, nephew that you want to leave something to, make sure you speak with an attorney about how to do your estate planning and how to set it up properly so that the minor can inherit that asset according to your wishes. And then another option we have here in Washington State is what's called the small estate affidavit. It is an affidavit that is prepared in regards to the assets of someone who's passed away if the value of their assets is under $100,000. So that is the threshold, that is the limit that someone can have for a small estate affidavit. And along with that, it does not work for real estate. Now, generally, if you own real estate, you would already be over the $100,000 limit as well. But if you own any real estate, the small estate affidavit will not work. But the small estate affidavit could be very good and very useful for clients. Maybe there's a smaller estate, just some bank accounts. And so it does make it easier for you and you are able to avoid the probate process. So that is my overview of how to avoid probate in Washington State. If you have any questions, please call our office. We'd be happy to help you. Have a great day.